Welcome to Case Flash, brought to you by the CBA Family Law Section. I'm Sam Schoonmaker, and with me are Judge Elaine Gordon and Attorney Alan Palmer. Case Flash today addresses the Supreme Court decision in Tuckman v. Tuckman. Both parties in this marital dissolution case had high income. The plaintiff husband worked in the financial industry and earned approximately $1.5 million a year. The wife had taxable income for several years, ranging between about $500,000 and $945,000, that income coming from a family business that was an S corporation. The parties had a trial on financial issues only. The wife sought an order of unallocated alimony and child support. The trial court dissolved the marriage and did not order alimony for either party. It instead divided the property and ordered child support in the amount of $250 per week per child. In reaching that decision, the trial court expressly found that it had considered the gross and net income of the parties. However, it made no net income finding, and it did not reference the child support guidelines. The defendant appealed. The appellate court reversed. It reasoned that the trial court had abused its discretion by neither following the child support guidelines nor deviating from them. As the trial court had not made a specific net income finding, and had not referenced the guidelines, in its remand, it remanded on all financial issues because it couldn't tell if the financial mosaic had been constructed correctly. The Supreme Court took the case on certification on two issues. After hearing oral argument, the Supreme Court asked for supplemental briefs on two additional issues that had been raised before the appellate court but had not been resolved by the appellate court. The Supreme Court went on to affirm the appellate court in a decision that goes beyond the appellate court's reasoning. The first question is to you, Judge Gordon. What was wrong with the trial court's application of the child support guidelines in this case?
Well, as far as I can tell, what was wrong is that they didn't apply the child support guidelines at all. And I think that this case really tells everybody that regardless of the amount of income that a family has, the guidelines at least have to be mentioned, if not actually considered. And I think that's what the Supreme Court was basically saying. It's what the appellate court was saying. Because if you look at this and you say, okay, they've got, they're way over the guideline, combined 4,000, even if their tax brackets are really bad. So the guidelines don't apply. I think what the courts have told us is that's not true. The guidelines have to be dealt with. And the appellate court mentioned and the Supreme Court pointed out that the guidelines themselves say that for couples making over $4,000 a week net, above that amount, they're on a case-by-case basis, but the presumptive amount has to be at least what it is at the top level of the guidelines. So it seems to me that you at least have to find that it's that there's a presumptive amount that you're moving up from or down from or whatever you're doing with it. But just like any other case, there is a presumptive amount.
This is a 2009 decision, and the Maturo decision came out in 2010. Attorney Palmer, what was the common practice, would you say, at least in some parts of the states, about applying the guidelines in high-income cases?
I think at a certain level, we just never even submitted the guidelines. They were presumed to not apply because the income level was above $4,000 or above $200,000 a year net. So they were, a lot of times weren't even submitted. There would be a simple reference that the party's income was above the guidelines amount, and the guidelines didn't apply, period.
Judge Gordon, was there anything about this decision that troubled you in any way?
Well, I think it's the part that talks about the finding of the net income, because I'm not sure what it means that we're supposed to find the net income. We have financial affidavits. I'm assuming the financial affidavit had a gross and a net on it, if the form looks like that. It's unclear, but I think there were child support guideline forms filed, worksheets filed. They have gross and net on them. So does this case now mean that despite the fact that we have things that give us that information, somebody has to say, I found the net income to be what it was on the child support guideline worksheet or on the financial affidavit? And if you don't, let's say somebody's over withholding, it now basically says that you're going to have to do, I think, the whole tax calculation, which at short calendar could be an interesting problem for a lot of people, because I can just tell you that the number of people who over withhold is huge. And you have to be able to eyeball a financial affidavit and see whether or not somebody's over withholding, and then you have to redo the whole calculation. I'm worried that that opens up the whole prospect of mathematical errors arising to appellate issues.
Does this put more importance on these the guideline worksheets that people submit to the trial court?
I think so, yes.
Well, I think that what it's telling us is that if you're accepting the guideline worksheets, or one party's guideline worksheet, because sometimes they argue the over withholding because you get two different worksheets, and you're fine, whatever one you're using, or whichever financial affidavit you're using, I think you're best off saying, I find the net income to be as reflected in, so-and-so's financial affidavit or their worksheet, so that at least there's a record, because that's what they're basically saying. I mean, we don't know what you did. You didn't give us a record. And if anybody had any doubt that the appellate courts really like the guidelines and want us to be, at least using them as a framework before we deviate, and they're taking seriously this idea that we're supposed to, pay attention to them because they're for the benefit of children and the, equal treatment of children and consistent treatment of children by the courts. And they like that policy. It's not so much they like the guidelines, they like that policy, that you best make sure that somewhere in your decision, if they're children, you've used the word guidelines and talked about why you're doing what you're doing. This case would have been much better off if they'd said, because they say above 4,000 it's a case-by-case basis. And so you have to go back and look at the financial affidavits and see what they're spending on their children. And then maybe that helps you figure out what the appropriate percentage is, appropriate order is.
Post-material, I think that's the way it's being done as well, is that you're looking now at the actual expenditures on behalf of the children, whereas before you were simply focused on the income and that was it. For those higher income cases, the expenses for the children become much more relevant.
Well, it's interesting because you're getting different schools of thought. There's the one school of thought that's saying, oh no, you're at 15% or whatever the top level percentage is, and they're just applying that across the board. And I'm not sure that that's correct given the other information in the guidelines about decreasing percentages with increasing amounts of money. But to me, it makes perfect sense that if you have a high income, high asset family, and they have so much money that they can spend 80% of their income on their children, then your order should reflect that. I mean, most people can only spend X percent on their children because, they don't have that much money to go around, and they're not paying for tuition or jetting their children to Aspen for vacation or whatever else they're doing.
Right, and a lot of those higher income cases also are very high asset cases,
Right.
And so it's not even, they're not necessarily limited by income on a year-to-year basis.
Right.
They have a lifestyle that needs to be maintained. The children have certain needs. It might be prep school. It might be a certain a station.
A
that they
station
have.
argument, right.
And that is almost irrespective of their of year-to-year income. Attorney Palmer, there's a second part to this decision that dealt with S corporation income. What did you take away from that?
Well, what I took away from S Corp, the discussion on the S corporation income, is that at least in this particular case, and I'm always concerned that we apply general rules when the case law says that it's case specific, but in this specific case, there was a history of the wife's family business retaining earnings and not distributing them to the partners, and this went on for a period of years. The Supreme Court, based on several factors, including the lack of control, the history of failing to pay out retained earnings, and the legitimate business purpose of retaining the earnings in the business, found that it was error to include the allocated share of the wife's income from the business in the formula for child support and alimony, and found that and credited, so surprisingly the Supreme Court credited her testimony that her income was $85,000, and that's what should have been included for purposes of alimony and child support. The second part that I found interesting from that discussion is that it left the burden of proof on the shareholder spouse to produce the information and establish the legitimate business purpose, the control issues, and the historical information necessary to sustain the burden.
Right. So in this case, the trial court looked at the parties' tax returns and saw the S corporation income, which might be capital gains and pass-through income from the corporation that she never actually got, and said that was her income.
Exactly. And what happens in an S corporation is that income to the corporation flows down to each of the partners in their respective shares. So if she owned a 25% share in the family business, she's ascribed to have received 25% of the income, whether or not that income is actually distributed to the partners. And in this particular case, there was substantial evidence that it was not distributed to the partners, that she simply received a salary of $85,000. So this was money that she paid taxes on that she never actually received. And then the trial court considered that income for purposes of determining alimony and child support.
The remand in this case was for a new trial on all the financial issues. Why is this case different from Maturo, Mostopoulos, Canary, cases that were remanded after reversals for child support, application of the child support guidelines? They were remanded for child support only. How come this case is different?
Well, I'm not remembering all the facts in all those other cases, but here where you had the S corporation income issue, that finding of the difference between 500 and some thousand or 85,000, was that the difference in a year, can make a huge difference in all of the orders, including asset distribution, as well as whether or not there should have been an alimony award, which there wasn't, and the child support order. I mean, that's a huge difference in income. And I'm not sure that in Maturo there was a dispute about whether the income found was correct, as opposed to, or in the other case, which I just blanked on, the long name.
Mostopoulos.
Mostopoulos, right.
And I think that's exactly right. I think that because there was a finding of income, that the income was not in dispute, the Supreme Court was able to really leave it as a very distinct issue. Here, without the finding as to income, the finding as to income may affect the assets, the ability to acquire assets in the future, the alimony in addition to the child support. And what's interesting in this particular case is we may have like a reverse double dip in a lot of ways, because all of a sudden the wife's income is reduced by approximately $500,000, and who's not to say that on remand the trial court shouldn't consider that $5,000 in the asset's value.
Right.
And this gets back to Judge Owen's decision at the trial court level about the formation of certain family trusts that occurred before the marriage. So this really opens up the entire box again in terms of how to divide up the family finances.
Right, and the decision does note there are numbers put on the business, a $2.7 million number on one of the entities and a $1.25 million number on another, and you're wondering if income is treated differently on a remand, whether it's going to affect the evaluations on those.
Now that we know that the retained earnings can stay retained and that the business can function as it has, it may affect value.
Which is an interesting issue under Sunbury, if we can have a remand and use the values of the asset as a date of dissolution, and then you're going to possibly change the way the asset is treated, for valuation purposes by how the income is taken out.
Well, but it still might be what the value actually was at the time, if and we don't know whose valuation figure they used and whether or not the retained earnings were counted in one way or the other in that valuation. But when you blow up an alimony, an income finding, it pretty much blows up the whole case.
Right. Yeah, because the income finding is so central. Right. It wasn't severable. Right. It was completely interdependent with all the financial orders. Right. And so this isn't the kind of case where you can just remand on a distinct issue like child support.
Right.
Yeah.
So the mosaic is alive and well.
The mosaic is alive and well, though one of the issues that the Supreme Court took on certification but did not resolve was the mosaic rule. The appellate court had reversed and sent it back for a new hearing without ever considering whether misapplication of the guidelines impacted the alimony and property awards. The Supreme Court took certification on that issue, but never actually had to reach it because it got to the S corporation issue and got to the net income finding issue, and because it resolved those issues, didn't have to get into the mosaic issue. But that issue is alive and well for another day. There might be, at some point, the Supreme Court may come back to how to apply the mosaic rule when a case is reversed and remanded by the appellate court. The Tuckman decision is a significant decision. Thank you for joining us for Case Flash.